So today's joint webinar will focus on R&D and innovation. We have two presentations for you. Firstly, Phil Waller, who's a tax partner at Ballards, who will focus on maximising your R&D and innovation after COVID-19. Phil is a tax partner at Ballards and has specialised in tax for more years than he cares to remember. He is heavily involved with the taxation aspects of R&D and previously headed up the R&D tax team from a top 10 firm before joining Ballards a few years ago. Ballards deal with a large number of R&D claims and have a significant number of clients in the tech sector. Secondly, we have Inga Anson, who's a partner in corporate in our Cambridge team, and Rajeshri Bojnani, who's partner in commercial and technology in our Thames Valley team. They will be highlighting and discussing key intellectual property related issues that tech and IP businesses should consider if they want to ensure that they're sale ready or investment ready. For those who submitted questions when they booked, thank you for putting those through. We will answer all the questions after the presentations to keep things moving. Please do use the Q&A button on the screen to ask further questions at any point during the webinar. To keep proceedings flowing, we will answer them all at the end, and we will endeavour to answer every question, but if we're unable to do so, we will follow up after the webinar directly, and we'll also post the webinar on our website. Let's get the ball rolling then and start with our first speaker, Phil Waller, tax partner at Ballards, who's going to look at a recent tax case and a number of issues arising out of the pandemic, and how this will impact R&D development, R&D tax claims, and also what you need to do in the future to minimise the risk of HMRC challenge. Over to you, Phil.
Thanks, Nicola. Good afternoon, ladies and gentlemen. Bit of good news this lunchtime. No, it's not what Rishi was saying. I actually put a tie and shirt on for the first time since the 16th of March, and I can still get in it. So lockdown hasn't been too bad. Could I have the first slide, please? What I want to do today, just give you a very short recap and then move into the COVID issues. I'm going to be talking today mainly about the small and medium-sized enterprise initiative for R&D, which is the employee numbers of 500 or less, a group turnover of less than 100 million euros, and a balance sheet, gross balance sheet assets of less than 86 million euros. I don't want to be condescending, but I'm presuming most people who are listening are going to be in that sort of range, or certainly not above that range. The other scheme, the RDEC, the Research and Development Expenditure Credit, is more for the likes of, I know, the likes of Glaxo, or even the banks or Tesco who've used it. Just a short summary to recap. R&D tax credit, it's 130% additional corporation tax relief, and I'm an accountant, so I like maths. What that effectively means is, for every pound that you spend on qualifying R&D, you get an extra 130% relief from the Exchequer, which effectively means the government are paying you 44p in the pound for every pound that you spend on R&D. Got to be qualifying expenditure. It's mainly salaries, but there are some other costs that you can put in there, materials costs that you might consume, a bit of material, consumable costs like heat and power, some subcontractor costs, some software costs. Sorry, I lost that there. If you are not in a tax-paying position, there is a situation where you can carry the losses back to a previous year. So because of COVID and the circumstances that we've had this year, there may be a number of businesses who are actually going to produce a loss. If that R&D increases that loss and you have sufficient profits from the previous year, you can carry it back, so still accessing your 44p. If you can't, what you are allowed to do is surrender that loss to the Exchequer, not at the same rate. It's effectively 14.5% of the 230, but that still works out at 34p in the pound. So you can get money back from the Exchequer in that respect. There are perhaps some organisations who will say R&D's like falling off a log, it's free money, and all you have to do is put your claim in and the revenue will pay the money into your bank account a few days later. Like everything, there's no such thing as a free lunch. It's not that easy. There are a few points that we need to consider, and I'll just run through these briefly now. forget R&D itself. There isn't R&D here, R&D here, R&D here. What you've actually got to do is carry out research and development as part of a project. The revenue are very precise about this. There can be aspects of a project that qualify for R&D expend and aspects that don't. The revenue do produce a very good schematic, and I've got a copy of that, a PDF copy that I'll be happy to send to anybody if they want it at the end of the presentation. But it just sets out where you've got start, middle and end, and the qualifying parts that are included within that. What you've got to have is an overall advance in science and technology. A lot of people with R&D have worried in the past about science. Yeah, it's people in lab coats, white coats in laboratories with test tubes. It's not just that. There's anything that involves sort of a technological aspect as well. It's not humanities, so it's not the arts, it's not economics, but anything that you can put some sort of technological slant on it, there's a potential claim there. You have to overcome a scientific or technological uncertainty. Well, what does that mean? That basically means you've got to sit down and think about something, scratch your head, there's a problem that you've got to overcome. If it was something that somebody could come into the office, the workshop, the factory on a Monday morning at 9 o'clock and solve it by 11 o'clock, chances are it wasn't sufficient of an uncertainty. The next point, by competent professional acting in their field, is very important. There's a tax case that I'll come on to that the taxpayer actually lost because they couldn't put a competent professional acting in their field before the court, before the first tier tribunal. What I mean by that is an engineering company's got a problem. It employs me for a day or a week or a month and comes in and says, right, Phil, fix that problem. I am not then a competent professional acting in that field. What you would have is people who have experience in the work that you do, preferably with some qualifications, certainly with experience. We as an accounting firm, if we wanted to develop an iPhone now, no, that wouldn't qualify because although it would be new to us, we've got no idea how that sort of technology works. There's a good set of guidelines, the BEIS, which I think is the Business, Energy, Industrial Strategy Department. Used to be BIS, used to be DTI when I knew it. Those guidelines were first published in 2000, which is how long R&D's been with us. Updated in 2004, and I think again in 2010. But again, a PDF of that I'm quite happy to send out. It's not a bad read. It's 13, 14 pages, fairly large print, gives some good examples or further definitions of what I've got on the screen here. It also has a number of examples where it might give you some ideas about where potential claims can be made. Could I have the next slide, please? Right, some current issues. I'm not sure how many of you were listening at lunchtime to Mr. Sunak talking about I think it's the job bonus scheme or the job retention bonus that he's looking to bring in now to pay employers £1,000 for every employee they bring back off furlough. I'll come on to that in a minute, but it will be a little bit, don't know necessarily the answer to that at the moment. Can I draw your attention very much to anybody who's had a CBILS loan or a bounce back loan? These potentially are extremely bad news from an R&D perspective, not from the fact that you're getting money that you can use in your business. R&D is what's known as a qualified state aid, and under EU law, you're only allowed one state aid for a project. So if you were to apply a bounce back loan or proceeds from a bounce back loan for somebody paying somebody's salary who is working on an R&D project, potentially that denies any R&D SME tax credit that you have or were going to put in on that claim and potentially previously. You don't lose out completely, it throws you back into the RDEC scheme. I didn't mention previously the RDEC scheme, rather than 130% benefit, it's only 30%. But if you effectively are using any of that money to pay anybody who's working on an R&D project, it will jeopardize it not only for this current year, but there's potentially a clawback. So whatever you're doing, if you've had CBILS, if you've had bounce back, make sure that you can identify where the money's gone, paying suppliers, paying landlords, paying members of staff who are not involved in any R&D project, but keep it away from anybody or any trace of anybody who can be shown to be carrying out R&D work. If it's all R&D work, I mentioned the point about a project before, make sure it's on the small project. So if you have a small, a medium and a large, if you're going to have to pay somebody's salary and you're going to lose something, make sure it's on the small project, not on the large one. The job retention scheme isn't so much of an issue. If you're operating the job retention scheme correctly anyway, those people shouldn't actually be working on any R&D projects. The whole point is they are away, they are furloughed. The government or the BEIS did update some guidelines, I think in May, to say that in their view, hopefully we could rely on it, job retention scheme didn't actually qualify as a state aid anyway, because it was available to everybody. There were no restrictions on it. The problem with CBILS and bounce back loans is they're specific to certain groups of companies under certain criteria. The argument being job retention scheme, because it's available for everyone, it isn't a state aid. I had on there part-time furloughing, again, should be okay. What I wasn't sure was going to happen, whether or not we were going to have a furlough situation from lunchtime, where they may be furloughing continuing for certain industries, hospitality, for example, because I think under those circumstances, it could potentially bring you within those particular guidelines, those rules, because it would then be for a specific sector rather than for everyone. So job retention scheme isn't so much of an issue. Say the CBILS, the bounce back, please be very, very careful. A couple of other things. There has been quite a lot in our press, the tax press recently, about HMRC perhaps tackling R&D tax claims with a little bit more vigour. As I mentioned before, there is a thought process that R&D is a free lunch. It's easy, you put a claim and you get your money back. The government have been recently, and I say recently, I think it was possibly last year, maybe even the year before now, time flies, they have brought in an anti-avoidance cap for R&D now. Any R&D claim that is made from 5th of April 2021, it has been deferred a year. If your R&D tax credit is greater than 3 times the company's PAYE and NIC cap, it will be limited to that. You may say, so what? If you've got a workforce of 200 people and 6 people working on PAYE, not an issue. Where it is going to become an issue is if you have people employed overseas, particularly perhaps in the tech sector. You've got computer programmers working in the States, in Europe, in the Far East. You're paying them, but you're not actually paying any pay-as-you-earn and national insurance because they're not resident here. So you've got a large payroll bill, but there's no tax and national insurance being paid over to the revenue. The other circumstances with consultants, you can have an R&D claim on a consultant who's working for you. You pay them gross. You get so much relief for this, for the relief that you're paying for them. But again, no PAYE or NIC. So it may affect people who are using external consultants or possibly externally provided workers from next year. So that's one part of that. The other thing is there was a National Audit Office report that was issued in February this year. And I may be going down a rabbit hole here, but that was looking at what was called the management of taxes. And this was how much tax relief is given away by the Exchequer every year. Apparently it's in the region of more than 150 billion. And when we think how much might need to be clawed back because of coronavirus, potentially a lot to go at. Now, the biggest issue on that, the headline one, is actually principal private residence. You may or may not be aware, I'm sure you are, when you sell your own house, even though you've sold it at a profit, you don't pay tax on that. It's capital gains tax free. That's the biggest loss of tax that the government have. The only thing that worries me a little bit is tax release for R&D are running at about £5 billion. R&D, I think, is very much in vogue with the government at the moment, but we are running into a situation where tax reliefs or taxes are going to have to be paid at some stage to pay back all this borrowing. And some of you may be aware of entrepreneurs relief. Entrepreneurs relief, it was only running at about 2.2 billion as a tax cost. Now, the government have said they were both there to encourage business, to encourage growth, all the rest of it. But there was a significant cutback on entrepreneurs relief last year, curtailing the tax relief significantly. Now, I'm not saying that R&D is also possibly in the sort of Chancellor's sights, But I think what it is open to is that if people are not putting in claims correctly, documenting stuff that they should be doing, there is more risk that the revenue are going to come and say, no, we're going to disallow that. And that brings me neatly onto the recent tax case of AHK Recruitment. That was a case where a R&D bureau went into a business, recruitment business, obviously. They were putting in some back office software to help them. I don't know whether there was legitimate R&D involved or not. I suspect that there was. We've certainly put claims in for clients who've had back office activity, but nobody appeared for the client. There was certainly no competent professional put forward, which the tribunal was, let's say, a little bit cross about. There wasn't substantiation of the costs. All that happened was basically the bureau that put the claim in, they went before the commissioners, and the commissioners basically said, well, look, you can't substantiate this claim. There's nobody from the company here to do it. The way you've set the claim out doesn't work. Now, it may well be that the claim was okay, but I say it was just the way it was badly presented. Coming onto that, if I can have the next slide. So quickly run through this. What you're looking at is the revenue do produce an online tool that asks a number of questions. They call it an online advanced assurance application. We don't use it, we just submit claims with corporation tax returns, but these are questions that the government ask. And what you have to look at when you're putting a claim in my view, is making sure you can answer these questions. For example, in question 1, what's your project plan? What are you looking to do? What's the current baseline available in the project? What do we know so far? What's current knowledge? What are current knowledge levels? What do we not know? It's a little bit Donald Rumsfeld's known unknowns and unknown unknowns. But if you can look to see where we want to take things, document what you're going to have to do to get there, and again, focus on the technological aspects. Now, it doesn't just have to be computer code crunching, but anything that's got a technological impact. Scientific technical advance being sought. How are you trying to move it forward? What can you do now? What are you looking to trying to achieve? What are the uncertainties? Why won't the current scientific or technological position where you are currently deal with it? Why can't you just do it immediately? How do you have to move things forward? What technological issues currently exist? How can you get around those? How does the project plan to deal with these uncertainties? So again, setting out what you're looking to do, where you are now, what you're going to do, where you're going to get to. And the fifth one, particularly the question, why is the knowledge being sought not readily deducible by a competent professional? This is what the revenue like to focus on. It's very important. You should have somebody in your project team who can lead it, who knows the subject, has perhaps got, if we're looking at an engineering issue, got an engineering degree, engineering qualifications, has been doing the job for a considerable amount of time, and they themselves are not easily able to solve the problem. They've perhaps looked elsewhere, they've looked at the technical journals, they've looked at their peers, looked at university studies. Now that's perhaps going to the extreme, and I wouldn't necessarily suggest that that's what you do in every case, but that's the sort of thing you've got to look at to convince the revenue. Next slide. Practicalities. Now, this is how the revenue would like you to do it. Most of our clients, certainly at the outset, don't do it that way, and I wouldn't necessarily suggest that you should. What I would just say is think as widely as possible about issues that you are doing, problems that you have in the business. Is there a technological aspect in how you're going to have to solve them? And then could that be categorized as a project? I'm not for a minute suggesting that we sort of go back and reinvent something, but if you've carried something out last year, the year before, because if you haven't made a claim yet, you can go back 2 years. You may be able to put it in some sort of format that you can say, no, this was a project. We had these problems. There was a technological aspect to it. We can build all this in. I've got on there, what's the overall advance? I mentioned on the first slide that has to be an overall advance in science and technology. Now, say you're looking at a stock control system. There might be an argument that, well, Amazon have sort of covered all ground in that. If Amazon have done it, they've got the advance. They're always going to be out there at the front because their stock control systems, whatever, I'm sure they run like clockwork. The information they have is, though, is going to be proprietary to them. you're not going to have access to that. You're still going to have to go back to the drawing board. So even though somebody else may have thought about what you're doing and even solved the problem you're looking at, providing it's not there in the public domain, it is something that you can still make an R&D claim from. So take away, just go away, think about any of the technological problems, scientific if you're in that sort of particular sector industry, but any technological problems that you've had to overcome, chances are there's an R&D claim there. And just finally on my last slide, just some examples that we have done, upgrading computer systems, off-the-shelf packages. Some people can acquire stuff from Excel, but it doesn't work, you've got to tweak it. Stock control system with a website, looking at something like that, interaction directly with customers, sending information down the line. Some of the stuff that's not necessarily that techie based, we've been involved with a client who's developing growing mediums in the horticultural sector, farmers looking at innovative irrigation sectors, CCTV, interactions with old stuff, current stuff, and how you're going to develop it for the future. A couple of sector issues, we're working with a dentist about teeth capping amalgams and what they're doing with that. And in the gaming sector as well, with a number of clients in that tech sector who are looking at, quite a lot of it is coding, but it's how that is involved in the overall project. Computer coding itself, just to make my final point, is not R&D in its own right, but if it does form part of coding, a part of a project, getting you from a start, middle and end, it would qualify time that you're spending on that, would or should qualify for R&D. With that, sorry Nicola, I think I may have run over just a little bit, but with that I will pause for breath.
Thank you very much, Phil. What a fascinating presentation. Lots of interesting things to reflect on there. So now, without further ado, I'll pass you over to Rajeshri and Inga, who will discuss and highlight key intellectual property related issues for tech businesses, which they should consider if they're preparing for sale or preparing for an investment round. So over to you, Inga and Rajeshri.
Thanks, Nicola, and good afternoon, everybody. So for any business looking at potential growth strategies, whether by way of a sale or key investment process, a buyer or investor will want to establish how the value in that business has come about, because that is essentially what they're buying or investing in. And they will also want a clear understanding of any inherent risks in that business, because clearly this could adversely affect the value of what they are buying or reduce their potential return on investment. In an IP or tech-rich business, there is a particular focus on understanding the IP landscape in which your business operates and establishing the nature of and the rights in those intellectual property or IP assets that are used by your business and which create the value in your business. To do this, a buyer or an investor will commission various searches and reports with a view to identifying those intellectual property assets and ensuring that you have the right to use them in the way that you do. Working here in the Cambridge market means that a large proportion of my work centres around early stage fundraising and growth funding for a range of tech companies, from fintech to agri-tech businesses, which makes us very familiar with the concerns and requirements of acquirers and investors in this space. So before we go on to consider issues around ownership and use of intellectual property assets and the potential pitfalls to watch out for when you are going into a sale or investment process, let's first take a look at the key types of intellectual property that are going to be relevant in the context of a tech IP business. Next slide, please.
So thank you, Inga. Yes, let's pause to think about what are the key types of IP right that we're going to be thinking about in the context of a tech IP business, IP-based business. I'm going to look at 4 categories, which I think are the most relevant. First, copyright. So what sort of thing are we talking about here in which we might have copyright protection? Obvious examples would be the software on my computer, a novel, an architect's drawing. Basically, copyright protects literary, dramatic, musical or artistic works, sound recordings, films, and the type of graphical arrangement of published work. For our purposes, think of it as any written or documented expression of an idea or concept with a degree of originality, but the threshold is relatively low. Think of original to mean not copied in any substantial way from another work for these purposes. Copyright protection extends to computer software. The source code is considered the written copyright protected work. Website content, databases. In fact, there's a separate database right that protects the systemized compilation of data. And copyright will also protect drawings, specifications, technical manuals, and crucially in this sector, algorithms. So not the output or functionality that the algorithm produces, but the written code that makes it up. Copyright arises on creation of the work product and is owned by the creator, be that an individual or a company. And something that's going to become relevant later for a company, we include where the work is created by employees in the course of their employment with the company. What does copyright give you? It gives you the owner the exclusive right to make copies and distribute the work, and other rights of exploitation like licensing. There's no copyright registration system in the UK, so care needs to be taken to keep good track of when and how key copyright works are created. Documentation, good record keeping is going to be key, and we'll speak more about this later and some of the pitfalls to look out for where this documentation and tracking is not quite done properly. Second category of IP right I want to pause on for a second is patents, and patents are all about functionality of a product or process. Basically, how does it work? So a patent is a registered right to protect inventions. It must be applied for, and if granted in the UK, gives a 20-year exclusivity to exploit the invention which is protected by the patent. Key elements that you need to be able to demonstrate to get a patent: the invention must be novel, it must involve some kind of inventive step, and that's all assessed against pre-existing knowledge in the relevant field, what is known as prior art in the patent world. And crucially, the invention that you're seeking patent protection for must be capable of some form of industrial application in the marketplace. It's important to note in the context we're speaking about that for software IT businesses in particular, the UK approach to patenting of software and methods and processes for that matter is more restrictive than the wider approach in the EU, and yet even more restrictive than the approach taken in the US. You can't have a patent for a computer program as such, but you might be able to get a patent for a wider product or system that runs on software. So as your business grows and develops, products and processes, consider whether patent protection might be available. Patents might not be so relevant for a pure software business, but could well be relevant, for instance, in an advanced manufacturing or a medical devices business. Third category of right, which I'll only pause on briefly: designs, potentially relevant. There's a registered design option available in the UK and the EU, which can provide exclusive rights to the owner over the appearance, shape, and configuration of a product. It's not about functionality, so designs are not about functionality. You need to go back to patents for that. And finally, trademarks. So if your product or services that make up the key value of your business have been marketed under a particular brand over the period of your initial growth, then it's worth securing registered protection for that brand if it meets the appropriate threshold of distinctiveness. A registered trademark provides exclusivity of use to the owner of that mark in respect of the particular goods or services for which it's registered. Without registration, brands in which a reputation has been built up in the marketplace can still be protected against exploitation by other people, but the process of doing that is much more challenging. So registered protection, if possible, is going to provide a great deal of reassurance to an investor. And finally on that, remember, as a question we get quite a lot, the system of trademark registration is different and separate from the system of company name registrations, and the system of domain name registrations is separate again. So that's worth bearing in mind. Next slide, please.
So having summarized now the key types of intellectual property assets that are going to be most relevant, let's move on to the concept of ownership. Your buyer or investor will want to know if you own or have a legitimate right to use the intellectual property that they have identified as creating the value in your business. as I mentioned earlier, the various searches and reports that the buyer or investor will carry out will help them to do this. So I thought it would give a bit more context to the importance of understanding how these seemingly abstract principles around IP ownership can have an effect on a real life situation by giving you an example of how it affected one of my clients recently. We were advising the client on a significant growth phase investment into their software solutions business. In helping the team to put together their due diligence data room, it became apparent that the company had engaged the services of a large number of consultants and subcontractors in the creation of the software solution that comprised the key product. These contractors were in and out of the business at various times in the growth of the business and the product. They weren't employees, but independent contractors commissioned to write code and algorithms and to advise and consult on the piecing together of the software package. These contractors were paid for their work by the company, but as it turned out, none of the work that they had created and which was part of the company's product was in fact owned by the company. So Rajesh, perhaps you could outline for us how, even though the company is paid for this work, it ended up not owning any of the work that was created.
Yeah, so I think the first thing we need to consider here is what we mean by ownership of the software solution that you were talking about. It's not a tangible product. So what is it that can be owned? What was the business asset that in future could be sold or licensed or form the basis of a revenue stream? And what it was the IP rights in the software. And for these purposes, the key right would have been copyright. So as we saw earlier, copyright comes into being on creation of the work product. So here, when the relevant pieces of software were written, and it's owned by its creator. So in this case, when the relevant pieces of source code were written by each of those individual consultants and contractors that Inga was talking about, that were commissioned to do the work. Copyright can only properly be transferred to another person or company if the creator, so here the contractors and consultants that were commissioned to do the work, transfers it by way of a written signed contract. And often in this context, that's called a copyright or an intellectual property assignment. So Inga, in your scenario, how did your team resolve the issue with the IP not being owned by the target company?
Well, as it happens, we managed to identify and track down each one of those consultants, and each one of them agreed at no cost to our client to transfer the relevant IP rights that they owned in the software back to the company. There was a real risk, however, that any one of those consultants could have been a bad actor, either by demanding some kind of additional payment or refusing to transfer the rights and effectively holding the company hostage in respect of those rights. Because in this case, the rights created by the consultants really did go to the fundamental value of the business, and the sale could quite literally have fallen apart if all of those rights had not been transferred.
Yeah, so I think that could clearly have been disastrous for the client. And I think it's worth considering how could that have been avoided in the scenario that Inga laid out. The answer is to have ensured that all the consultants and contractors that were involved in the development of the solution had signed written transfers of their intellectual property rights to the relevant company before they even started working on the programming. An assignment of rights of that kind can pick up rights created in the past and rights that might be created in the future. So even if, for whatever practical reason, that those assignments had not been able to be signed up before the consultants and contractors started working on the project, they should be done as soon as possible, and they could pick up past and future rights relating to the project they're going to be working on. I mentioned before when I was talking about copyright that if employees of a company create copyright works, then the position under English law at least is that by default the copyright in those works belongs to the company. But it is still good practice to also have one of these IP transfers or IP assignments in employment contracts to ensure that there's no doubt about the fact that the intellectual property rights that the employee creates do in fact end up belonging to the company they work for. So in a moment, we're going to move on to IP rights used in the business, even though not owned by the business. But before we do, while we're talking about rights that are owned by the business, it's worth just pausing on a couple of points which would be relevant to an investor's or a buyer's assessment of the body of IP rights that they're examining in the due diligence process. So the first of those 2 points I want to mention is that we've talked about the registered protections available for intellectual property, depending on whether the relevant product qualifies. So consider whether your business has looked into what is available to best protect and maximize the value of its IP assets. So if you take patent protection, that 20-year exclusivity on exploitation of an invention product process that's covered by a patent is going to be very attractive to an investor. And the second point I wanted to highlight in terms of rights that the company owns, think about out on the journey of growth whether you as a business have granted to anyone else, manufacturers, suppliers, distributors, business partners that you're working with or consulting with, have you granted any rights in your intellectual property to those third parties? And if you have you done that in a way which restricts your own ability to use those IP rights going forward, and for how long? Remember that when an investor or buyer is doing one of these due diligence processes and looking into whether they're going to invest or buy your company or business, they're going to be looking on any restrictions that have been created over the company's IP assets in that way. So having talked about rights that the business owns, let's now move on to IP rights that might be crucial to the operation of your business, but which your business doesn't actually own. Next slide, please.
So where your business or company does not own the IP rights it needs or is using, an investor or buyer will want to understand the legal basis on which you actually do use those rights. Do you have the relevant or necessary permissions or licenses to use those rights? Intellectual property rights, if you don't own them, cannot generally be used or exploited unless the owner has granted permission to use them, generally and usually in the form of a written license. If your business does not have the relevant licenses in place, you could be infringing the owner's rights, who could ultimately prevent or block you from using that intellectual property. And any investor or acquirer will want to make sure that this cannot happen, where the use of that IP is fundamental to the business. To demonstrate how these non-proprietary rights can become problematic if not properly managed, I'll turn to another recent transaction on which we acted for the sellers of a business where the key product was a business-to-business software solution. As part of its due diligence, the buyer commissioned a specialist report, the purpose of which was to specifically identify the key proprietary and non-proprietary software and to establish the correct lines of ownership and use. And what the buyer here found was that the key product was built using various bits of open source software, or OSS, which is software, I think as many know, that is generally made freely available on the web by its creator, and that the integration of some of that open source software into our client's own proprietary software had effectively ended up damaging that business's own IP.
So, as Inga indicated, open source software in its simplest form is software that's made freely available for use, which sounds simple enough, but how can it create a problem? So when open source software is licensed along a chain of users, it's important to remember that it's still subject to certain rules of licensing. So for instance, license terms attaching to different categories of open source software might contain requirements that certain notifications or attributions are passed down the chain in subsequent licenses, even where that open source software is incorporated into a wider proprietary product. Or the open source license terms might stipulate that it must be distributed, the open source piece must be distributed without any performance or fitness for purpose warranties, even if the ultimate software developer is providing some warranties and assurances around its proprietary piece that it builds, layers onto the open source software. So the problem arising on the transaction that Inga was just describing is that the open source license terms meant that any software product built on or that was based on the open source piece, in other words, a derivative work, would become, albeit inadvertently in this case, also freely available for use along with the open source on which it was built. In order to avoid that scenario rising, clearly one which could be devastating to the value of the business, you need to take great care when using open source products as the foundation or as component parts of your software solution. Pay attention to the license terms that the OSS pieces come with, and particularly if it's what's known as a restrictive license or a copyleft license, as opposed to copyright, then you potentially end up in the situation that Inga described, where the open source product has effectively polluted the proprietary software that you've built on top of it, so that the proprietary software that you've built also becomes freely available, unless the open source piece can be easily separated out, which is not always the case.
Yes, and on this transaction that I mentioned, we had to identify each item of open source that had been used, the terms that were applicable to that open source, and what this meant for the business's product going forward. No investor will have wanted the key proprietary product of the business they're about to invest in to become freely available for use in the market for obvious reasons. But as it turned out, in this particular case, the piece of software that had been built on the copyleft open source had already been rewritten and replaced by the client. So the fact that a prior version might become freely available turned out to no longer be of great concern to the investor. But I think what this scenario highlights is the importance of checking the basis on which your business uses and can use going forward intellectual property rights that have been licensed in by others, and the importance of ensuring that those licenses are in order. Next slide, please.
Thanks, Inga. So sticking with our theme of IP rights that are used in the business but not owned by the business, so they're licensed in from other companies or individuals, it's worth also thinking about what terms those open source aside, when we're talking about third-party proprietary software, what other factors do you want to consider when you get to the sale or investment scenario? And what is the investor or buyer going to be looking for when examining those third-party license arrangements? So you've got licenses granted into the business. What's the investor, buyer looking for? And one of the things they'll be looking for is any terms of those contracts that are particularly onerous and which will attach to the business going forward. So for example, do they contain an expensive long-term royalty commitment, or has the business ensured that it's been granted exclusive rights in the key field of use that the investor is going to be interested in? Or can the IP owner also share those rights with others? Does the IP owner have the ability to terminate those licenses to the business on short notice? All of those things, of course, are going to be of interest and concern to the investor.
Yes, and also just the investor or acquirer is going to want to establish that the sale of the company or business or its assets or any investment transaction that it's undertaking is in itself not going to affect the ability of the company to use the key intellectual property post-investment or acquisition. So part of any due diligence process is trying to establish whether the investment or acquisition might affect the ability of the business to continue to use those key rights.
Yeah, so often licenses granted by other IP owners into the business will have terms in them which state that the sale of the company or change of control in the company will mean that the license comes to an end. So the investor or buyer will be reviewing key licenses to make sure that that's not going to happen. And if it might happen, what, if anything, can be done to negotiate the ongoing use of those rights. Similarly, licenses of IP to the business will be considered an asset of the business. like any key contract which under which the business derives a benefit or has acquired rights. So if the key assets of the business are being sold, then that license of IP will be one of the assets and will need to be transferred to the buyer. Such licenses will often have restrictions in them, in fact, very commonly, which prevent this from happening, which prevent the transfer of the license, or at least prevent the transfer of the license without the permission of the owner of the IP. So that's another potential stumbling block to navigate, and something perhaps for the business to look for and negotiate around with the IP owner in advance of planning ahead for a sale.
Thanks, Rajeshri. And so that ends the formal part of this webinar, but in summary, where a fundamental part of the value of your business is based on intellectual property assets, make sure you are tracking those assets, both in terms of what they are, who owns them, and who's allowed to use them. Make sure that as far as possible from the outset, you have protected that intellectual property and keep it adequately protected. And then keep in mind the impact that any transaction might have on your ongoing ability to use any of the key IP rights and how that might affect any acquirer or investor's appetite for a transaction. So I'll hand back to Nicola and the Q&A.
Thank you very much, Inga and Rajeshri. Very interesting presentation and a great insight really as to your practice and experience in working with IP-rich businesses and the pitfalls that they face on a day-to-day basis. It's not for the faint-hearted, is it? So thank you everyone for the questions coming through, and we've got quite a few, and also some that were sent through when people registered for the webinar. So I'll crack on. We've got about 10 minutes and we'll try and answer all your questions, but if we can't, as I said, we'll follow up afterwards with you individually. So I have a question here for Phil. Phil, we're constantly updating our internal systems to match customer demand. We have an IT team of 6 individuals who are always working on this. How much of their time can we claim as R&D expenditure?
How long's a piece of string? No, it's not quite that. I suppose I'd have to take it back to sort of first principles, that what are the actual R&D team doing? It's sort of updating systems constantly. I'd come back to that situation of what's a project? Can you actually break down what they're actually working on? Is it this particular project, that particular project, this particular project? It may involve a little bit of thinking and not quite timesheets on their part, but what are they dealing with? I think then it would be looking at what are they doing within those particular boxes? What are they doing that's actually, you would say, no, they're moving things forward, as opposed to actually perhaps from an IT point of view, what you might call bug fixing. I think what you're looking at is where we are creating something new, where we've got that advance in the technology. So I think I'd look at it to say, right, break it down. You've got your team of 6 people for the year. What have they actually been working on? Are those the bits that you're sort of dealing with, matching customer activity? Is it something that you could just say, no, there are 3 or 4 distinct little projects that we've got in there? So 6 for 3 or 4 areas of work. And then of those areas of work, how much time could we actually say we've been doing something innovative in there, rather than no, we've just been sort of bug fixing? Now you can have a circumstance where you've almost got project 1, 1.1, 1.2, 2.0, 2.1, 2.2. So it's almost a continuous project, but there are different stages at it. The revenue also accept that, these iterations. You can almost go back when you've gone from say 1.2 back to 2.0. On what on that project you've actually said, again, what then is the innovative part? And including innovative, it's moving that whole innovative section, so you could have testing of it or whatever else. It's just a straightforward, I say, bug fixing that you can't do. So I suspect probably quite a lot of it, but it does come down to almost putting it into the boxes that the revenue actually look at to say, what's a project? Who's looking after it? Who's the project lead? If there's a head of IT, it's perhaps that person. It's then saying, right, how many people have been working on that bit? What have they been doing? What was the problem? Why did we have it? Why did we need to move it forward? Almost going back to those questions that the revenue ask. And I think if you can box it into those pigeonholes, then allocate the salary costs against it, then I think there's a good opportunity for a claim there.
Thank you, Phil. That's very helpful. Now I have a few questions Live questions. So I have one here for Rajeshri. I've had software developed by consultants outside the UK. I want to IP the development. Is it too late to do something about their contract? They started working in later 2019.
Thanks, Nicola. So it may not be too late. When we're talking about software, and the questioner is saying they'd like to IP the software, so certainly from a UK and EU perspective, there's no copyright registration system, and copyright is likely to be the main intellectual property right that is relevant here, that could give you protection in your software, essentially your software code. And if you've had consultants, whether in the UK or outside the UK, involved in the writing of that code, as I was mentioning earlier in one of the transaction scenarios that Inga talked about, it's not too late to get assignments of the rights of those consultants signed up and drafted in a way that would make sure that any intellectual property that they've developed and therefore own in that software in the past, and any, if they're still doing the development that they might create in the future, is transferred to you or your company. It's not too late to do that. Obviously, how you approach the question in retrospect depends a little bit on your relationship with those consultants. Hopefully it's collaborative and friendly and they'll understand why you're doing it if you haven't already signed up a contract with them. But remember that you'll need to approach it with some care if you think there's going to be any challenges there, because the consultants might understand why you're asking and realize that actually you might be a bit stuck if they don't transfer their rights. Hope that's helpful.
Thank you, Rajeshri. That's great. So I have one here specifically for Inga. So what is the most common problem you see with tech companies when they come to sell? That's a challenging one.
Not that challenging. There isn't. I wouldn't say there is a common problem or a common theme of problems with IP or tech businesses. Many businesses have problems that are essentially generally unique to them. But this is partly why we are raising the issues that we raised on the webinar today, because if there is one thing that IP and tech businesses really need to focus and take great care about looking after is the IP, or understanding, you know, what it is they're using, how they're using it, how they're documenting it, how they're protecting it, because that is where the value is in these businesses. Nobody really cares too much about how many employees you have, whether they all have an employment contract, but what they do care about is, this is what makes up this product. Do you own it? Are you allowed to use it? Could we sell it? Is it being properly commercialized in the right way? I think that's the key focus for any IP or tech business.
It must be quite challenging having those conversations with entrepreneurs when they get to the stage of selling their business and then find out that actually they might not own what they think they own. So that must be quite complicated and difficult to manage, I imagine.
They're generally quite receptive. You know, we're often talking about smart people who perhaps understand what they don't know, and are happy to be led by, you know, people like myself and Rajeshri in making sure that they get that right. Absolutely.
Thank you, Inga.
Nicola, I think you need to come off mute.
Apologies. Thank you very much. I have a question here for Phil. You didn't mention subcontractor costs, and I believe they're a qualifying expense. However, that's not the question. The question is, where do you draw the line as to who can claim R&D relief? If a subcontractor is carrying out work for a main contractor, who's actually carrying out the R&D?
Ooh, good question. I think it will depend. It depends a little bit on the size of the contractor, the size of the subcontractor. I mentioned before there are two regimes. There's the RDEC, the research development credit, and then there's the SME scheme. There are different rules depending whether it's a large company contracting to a small company contracting to a small company. I think the things to look at is to say, you, the actual company that's looking to claim the R&D, is it an sorry, it's back to first principles again. Are you the R&D company? Are you carrying out a project? So you could have a circumstance where company A is carrying out some R&D, but it has to then subcontract some testing of that project to company B. It would probably form part of a subcontractor cost for company A because it can then carry out that. It's part of that overall project, the testing of it. As far as company B is concerned, who's actually carrying out the testing, there it becomes a little bit, well, what are they doing? If they're just literally doing something that they do every day of the week, it wouldn't be something, there isn't anything innovative that they're doing. If that's been subcontracted out to them, but then they themselves have to come up with an innovative way of dealing with that, then I think there's a charge that company B would make to company A that could be claimed by company A. But the fact that company B is having to do something innovative that, say, can carry out the testing, it would also have a claim. So it's really looking at going back to that principle. There's a project, there's a start, there's an end. What you're doing through it, is it innovative? If you need some help employing a subcontractor or an externally provided worker coming in to do it, you can claim those costs. The subcontractor themselves, it is possible you could have two companies making a claim for what would potentially be one overall development, but it's looking at each individual company, their own position. So, sorry, it depends.
Thank you very much, Phil. Very, very helpful. So we have a couple of minutes left, so I'm going to wrap up. Any questions we haven't answered, we will follow up with you individually. So thank you for submitting those. Thank you to Phil, Rajeshri and Inga for your fascinating insight and tips and recommendations to tech businesses and IP-rich businesses. Thank you also to everyone who attended and joined us this afternoon. Please keep monitoring our websites for HCR and Ballards for upcoming webinars, articles, news in the tech sector and also more widely. As I said, we'll commit to posting our this webinar on our website, and we will also come back to you with the answers to the questions that we've dealt with today. But thank you everyone for joining us, and we look forward to engaging with you again in the future. Good afternoon.